This is the American Law Journal.
Are injured workers losing the medical battle? Well, the way cases are settled nowadays and a new law that may go on the books, you bet they are. Good evening and welcome to the American Law Journal. I'm attorney Christopher Naughton, and there was a time when you couldn't settle your case in workers' compensation, and now you can. That sounds like a good thing, right? What happens when the money runs out and you still have medical bills? The Legal Intelligencer's Gina Passarella has this.
Call me right now, 459-CASH, 459-CASH. I'm waiting and ready to go after your award.
You've seen personal injury commercials, right? Get injured, file a lawsuit, settle. But a work injury is not a personal injury. Under workers' comp, there's no award for pain and suffering. You only get a fraction of your wages. And settling your workers' comp case can be trickier.
Once you settle your workers' compensation claims, you cannot have your case reevaluated or open that case back up. The one more common exception is if your settlement includes open medical benefits.
Open ongoing medical benefits today are rare. Lawyers and judges tend to settle almost everything, and that, some lawyers say, can be a problem.
Years ago, the medical aspect would always remain open. So what has been happening over the course of several years is the claimants are enticed to settle the medical aspect of their claim. I mean, the concern is that within a year or two, there's no more money, and they need medical treatment for a severe work injury, and the concern is how are they having that medical treatment paid.
I think all too often medical gets brushed aside.
Claimant's attorney Christian Petrucci says in a settlement, lawyers must be adamant about the value of their client's medical benefits.
In the cases where an injured worker needs medical, that has to be on the table, and oftentimes I will ask for a life care plan, which is an expert report designed to demonstrate the value of the future medicals. And if that's an element of the settlement that has to be presented, whether it's part of the insurance company's economic reality or not.
In the end, injured workers should never feel forced into a settlement. Trust your instincts, your lawyer, and the judge.
I think anybody can find an individual case where they don't want to settle and maybe they're feeling pressure to do so by the system. But in the end, it's really up to the parties. Do you want to settle the case or not? The judge is not going to make a claim and settle a case if they don't want to.
For the American Law Journal, I'm Gina Passarella.
Settlements become all the rage in workers' compensation. Is that a good thing? Let me ask my four guests. George Beatty weighs in tonight with Beatty, Sloan, and DeGeneva, over 25 years, representing claimants in personal injury matters, including medical malpractice, products liability, and, of course, workers' compensation. Jeffrey DeLynn, the Honorable Jeffrey DeLynn. Judge DeLynn, for many years here, 10-plus years on this set. Judge DeLynn weighed in because we had invited him, and he was gracious enough to accept our invitations as a seated member of the judiciary, a workers' compensation judge, now a partner with Krasno, and Owen Dinjo in Philadelphia, Pennsylvania, also representing claimants. And Barbara Young is with us for the first time with Schaff and Young, also centered in the Philadelphia region. She represents the insurance companies, the employers, and the third-party insureds. And the judge on our set tonight, the current judge, the Honorable Audrey Beach, joins us again this evening, and it's been a while since we've seen Judge Beach, seated in the greater Lehigh Valley, correct, Judge?
That's right.
And as a seated judge, do you go to any other areas, or you pretty much, your courtroom is there in the Lehigh Valley, and that's where you're placed?
My courtroom is based there, but I do mediations in other counties.
All right, let me go to you first, actually, Judge. The whole notion of settlement, I get a chance to talk to judges and lawyers. Settlements become all the rage, but there was a time, first off, what is a settlement, Judge? And secondly, it wasn't that long ago that people that got injured on the job couldn't settle their cases.
Well, I'm dating myself, but back in the day when I practiced, you could settle just the indemnity portion of your workers' compensation case, and as that little snippet demonstrated, that the medical benefits remained open, so that really wasn't an issue with the medical benefits. But that was called a commutation, and it developed as a way to get lump sum money to a claimant who would otherwise have to wait over a 500-week period and have those weekly benefits parsed out over 500 weeks. Instead, that they had the benefit of the lump sum.
All right, so Barbara, not unlike a personal injury case where people, if they get injured, they negotiate with the insurance company, they get their medical benefits, they get their wage loss, that sort of thing. There was a time, as the judge was just saying, you just got your wage benefits, but your medical benefits were paid to you over a period of time. There's a sort of a safety gap, but that safety gap, if you will, is missing right now, or could be missing when it comes to settlements nowadays.
Well, not necessarily. I mean, you want to look at the entire case. Everyone knows what they're dealing with. There are situations where medical continues and will continue.
But that's rare.
It isn't rare.
It isn't?
It isn't rare.
Okay, well,
it isn't rare.
Okay, really? So does it continue that much, George?
In my practice, it certainly does. I mean,
in your practice, it does. But I mean, what is the word on the street?
The word on the street is a lot of times there's pressure to get the case settled. Sometimes the claimant wants his case settled or her case settled, and they'll give up the medical. But I'm there as the counsel for these people, and I explain there's two parts of the case, sometimes more than two, but usually two parts: the wage losses and the medical. And you need to anticipate what's going to happen and try your best. Sometimes it's done with money, sometimes it's done with years, sometimes it's lumped into the whole settlement. But it's something that we're always conscious of.
And Judge DeLynn, what is it? Your experience, again, formerly on the bench, but now in private practice. Don't you see that most times when lawyers go in to discuss a matter with a judge, they're really talking settlement most of the time?
I think it's much more attractive to the insurance companies to settle the whole thing lock, stock, and barrel. And just like so many other things in life, timing is everything. And when you go into the mediation, if your client is actively treating or is ready for surgery or just had surgery, there's no way that you can really, in good faith, settle the medical. There are other times when the treatment is winding down or has stabilized and has become more predictable, when you can build that into the lump sum if the insurance company doesn't want to keep medicals open for a period of time.
Well, this is something interesting. You saw Christian Petrucci, who's a workers' compensation attorney. He was in our feature report with Gina Passarella. Here's what he said not that long ago in the Legal Intelligencer. Modern settlement focuses on how many years of indemnity benefits a case is worth. It demonstrates that the medical piece of settlement is not being considered at all. The overwhelming difference, of course, is that claimants no longer get their future medical expenses paid. Some return to traditional settlement valuations is warranted. Judge Beach, let me go to you. Since, again, you have the most objective view tonight, do you find sometimes, and look, I've heard this from New Jersey and Pennsylvania judges, and they'll remain anonymous, but they say sometimes that lawyers are getting a little lazy, the judges are getting a little lazy. When they come into a courtroom, they're almost expecting to settle. And as you saw from Christian Petrucci, a lot of folks are not even looking at the medical, or they're at least glossing over it.
Well, there are attorneys, and there are three of them on your panel today that I know end up initiating talks about mediation at the right time, as Judge DeLynn said. There are other attorneys, and they're very, very few, and they're very far between, that merely get into the courtroom so they can generate mediation, a mandatory mediation or a voluntary mediation to trigger a settlement. But they're very few and far between. Judges lazy? Yes. I mean, there's a mandatory system and a voluntary system. Some judges have a lot of cases and they can't fit in the mandatory mediations into their schedule easily. They do it because it's mandatory. But it's a relatively new system that it is mandatory, and I find there's a big difference between the mandatory mediations and the voluntary mediations, as far as pace, as far as timing, and as far as substance is concerned. But I don't necessarily agree with the characterization that there are lazy lawyers and lazy judges.
Well, the good thing about a mediation is that it's non-binding. A mediation is something where both sides get to size each other up. We get to put this, when I do a mediation, I bring in all the guns. I lay the cards on the table, and I want to show Barbara or whoever it is on the other side that we're gonna really score big on this case. We're gonna make your insurance company pay very, very dearly. So either we settle for something that is really fair for my client and his future, whether that means medicals stay open or not, and it's certainly a component of the settlement.
And that's the point of the whole mediation process and what we do as lawyers. Your level of preparedness is really the manifesto that comes from Christian's article. Everyone needs to know all the parameters of the case so that you can best represent your client.
But part of what he was complaining about is that, and maybe it's younger lawyers, maybe it's lawyers who are, let's face it, You get a bigger payday when you get a settlement. And there is a pecuniary driving point, maybe for some lawyers to go ahead and see the bigger number on the table. This is not a comfortable conversation for lawyers in this area of practice. But if you're a young lawyer and there's a big number, they may be quicker to get that bigger number. That's good news for you, Barbara. You're settling the case, and they do gloss over the medical sometimes. Maybe not the best lawyers, but you see them glossing over it, don't you?
One of the problems, I think, is that sometimes a judge or sometimes a defense attorney or sometimes an insurance adjuster will put a number of years on it and say, we're going to pay you three years on this. You're not going to get more than 5. And when you do it just like that, it's true. People aren't considering the medical. And I hate to say I'm one of the old guys now, but we push back. I mean, I've been there before this all went into effect, and I'm not going to just sit there and let that happen to my client.
Judge Jeffrey DeLynn.
Chris, picking up on your question to Judge Beach, there are lawyers out there who take a case hoping that it will settle quickly, but I can assure you, having been on the other side recently, that there are cases that I think should settle. I recommend to my client to settle, and they really do need to get settled. But you know, if I'm up against Barbara and she doesn't think the case is ready to settle, and she's got to do her homework, she's not going to dial it in. She's going to fight as though we're going to decision, and everybody has to step up their game. So there is some laziness, but I haven't seen it so far.
And I think that 3 to 5 year range that everyone's talking about is a guideline. It's no one has to abide by that guideline. It's usually a starting point when things go from there. But it's simply a guideline. It's not a mandated directive as to how much your case is going to be worth.
Oh, I totally agree with that. I think part of the problem is a younger lawyer may be intimidated in that process where somebody's saying, look, you're going to get no more than 5 years. And you have to be able to say, no, I'm not going to, no, that's not going to happen in this case.
But Judge, George, and then Judge Lynn as well, as claimants attorneys, how many times do you hear people come to your office after they've already been represented maybe by another attorney and say, I'm 3 years in, I still have medical bills, I don't have any money left. What do you tell them? Well, you made a bad settlement, or your lawyer made a bad settlement. Or maybe, Judge Lynn, perhaps they didn't save their money. I mean, part of the settlement is you've got to take that money, sock it away, invest it, save it, make sure that when the rainy day comes, if you've got a medical problem down the road, you've got money. I don't know if it's human nature or not, but I'm sure you hear those stories.
There are those stories, and they're terribly sad, and sometimes, you know, you really cannot revisit a settlement if everything's been done properly.
Right.
And your heart goes out to these people. But on the other hand, they made a decision at the time they made the decision that was the right move for them. What happened afterwards is not necessarily within the control of the lawyer who handled the case. And, you know, maybe they made an unwise decision in retrospect. Maybe they didn't. It's hard to go back and look at that and second guess that.
All right, folks, well, let's switch gears here, and I should have mentioned right at the top of the show, we are taking your phone calls tonight, 1-800-426-4625. Call in, call early, because often we get our calls right towards the end, and we can't take your calls right at the end of the half hour. Or you can email us at info@lawjournaltv.com. Well, again, part of what tonight's program was about are workers getting squeezed when it comes to medical. Now, there is a bill. Let's get this graphic up on the screen. And I've seen this bill come up 100 times already. It's Pennsylvania Bill HB 808, a bill that would extend from 90 days to 180 days, the period during which an employee who has filed a workers' compensation claim must seek treatment from an employer-designated medical provider panel. Go to claimants' attorneys first, George Beatty and then Judge Lynn. Why is that such a big deal?
It's a big problem because if a guy's on the panel, he's being paid by the employer, by the insurance company. He has allegiance. Why is he being paid? Are you going to pay somebody that's going to cost you money? Or are you going to pay somebody that's going to say, everybody's okay? So, you know, when there's a panel doctor, the longer they're on it, the worse it is for the employee. And follow the money. Follow the campaign money, because the Republicans, financed by the insurance industry, want to change laws like this to hurt workers. When the Democrats get in, unions support Democratic candidates, and it goes the other way. So when I got out of law school, it was 14 days you had to go to a company doctor. Then it was 30. Now it's 90. They want to make it 180. And it just, you see the trend politically, and follow the money. That's what I say.
Judge, what's the big deal about having a panel doctor look at me if I get injured in those first 90 days and they want to move it to 180 days? I can still see my own doctor, right?
You can see your own doctor, but the workers' comp insurance company will not pay for it. So if you happen to be lucky enough to have health insurance, then yes, you can go to your own doctor. But a lot of doctors, if they hear it's work comp, even if it's your family doctor or an orthopedic surgeon you happen to know who will see you, they don't like getting involved when they're getting paid by health insurance if it's really a workers' comp case. And you know, Chris, there's a problem. When you think about it, if you're an HMO patient and you have to get a referral to somebody within the network, well, you at least have some choice as to who's in the network. With a panel doctor, you don't get to choose, and you're stuck with a doctor who doesn't necessarily have your best interests at heart. And I've had doctors say to me, you know, we're under pressure to get your client back to work, release them to work, even though they might not be ready to do so. That's the problem.
Claimants are complaining, Barbara, but I mean, this bill has gone up and down the hill, what, 80, 90 times. I'm being facetious, of course, but I think it's at least the fourth or fifth time that I've heard claimants' attorneys saying, it's coming, and now again, they're going to reintroduce it into the legislature this year, apparently, but it's never passed, even with the Republican legislature.
That's correct. Unfortunately...
Much to your chagrin, no doubt.
I do take issue. There is a choice. There are 6 healthcare providers on the panel. An injured worker has the opportunity to choose from that 6. They have an opportunity to have a second opinion if they're in disagreement with a treatment plan. And the fact is that the Department of Labor and Industry commissions a study every year, and that study's indicated that sampling injured workers, 87% of them believe that the panel doctors are as good as or better than any other healthcare provider. 71% of those surveyed indicate that they had no issue with their return to work status. So that something's working and people are getting quality care and efficient care.
Most cases don't result in litigation. Most cases are quick, one and done, out of there. So I'm not surprised by those kinds of numbers. The problem is, and people don't realize this, is that if they don't have a lawyer, they think, oh, I have to go to the panel doctor. Most of the time, they probably don't, because there are a bunch of hoops that the employer or the insurance company has to jump through. They have to post a list of doctors. They have to have an acknowledgement signed by the employee. And they, in most cases, don't have that. But people don't know about that, and they think they have to go to the panel doctor. Many times they don't. If they had legal counsel and we could, investigate that, sometimes they don't need to do that. They could go to whatever doctor they want. The problem with that is, of course, they won't get paid right away. They have to wait to get paid until we win.
Well, and actually, to your point, George, in order for a worker to actually be, if you will, tethered to only a panel doctor, the employer has to jump through a few hoops first. He's got to post a list of doctors. He's got to give you a choice of doctors. The employee must receive, acknowledge, and understand the notification, and only written acknowledgement suffices. So that, Barbara, seems like it's a fairly tight hoop for you folks to jump through.
That's correct.
I don't know how many people actually challenge that, or how many people, and Judge DeLynn, how many people actually do you think are aware of the fact that they could go to see someone other than the panel doctor, that they didn't get proper notification, that they have other options?
A very small percentage.
That's the problem, isn't it?
They believe that what their employer tells them, they believe what the insurance company tells them, and oftentimes they're not getting the correct information.
Let's go to some of your emails. Let me go to email number 1 from Phil in Conshohocken, and here it is. After I pulled my back real bad at the job, they told me to see a doctor from a list they gave me. I did not like this doctor, and he did not like me. I was in and out of there in 15 minutes. And then I went to another doctor, and he agrees with me I should stay off my feet before I talk to a lawyer. What should I do next? George Beatty.
He said, before I talk to a lawyer, what should I do next? I think you should talk to a lawyer immediately, because that's the only way you need to assess the situation and get some professional advice, because Barbara's are out there, and she's wonderful, and she's nice, but she's good. And the insurance companies are too, and they're much more sophisticated than an injured worker would be.
Within the Act, he has the opportunity to go to another person on that panel, and he should exercise that act as well.
Judge, do you think there's much of a chance that this bill is going to pass? I mean, again, I know we try to keep all of our judges out of politics, but how would let me ask you this is probably a more pertinent question. How would this really impact what you do? Because from what I understand, panel doctors really don't appear in front of judges very often, do they?
Yeah, Judge Beach, right?
What did I say?
Either judge. Well, you said judge.
I'm sorry, Judge Beach. Sure. Yes, I'm sorry.
How it impacts the litigation in front of me is, as far as what testimony is presented. The claimant will often say, I never saw a panel physician. I never signed off on any acknowledgement that I saw panel physicians. posted in the lunchroom, which is the usual place. And then there's testimony from the employer saying, well, you know, it's been posted there for 10 years and we update it every so often, and here's the signed acknowledgement that you signed when you got hired. Also, what I think is pivotal with this is those panel physicians have a longer period of time, good or bad, and they might be wrong, they might be right, to define what that work injury is or isn't. They have a longer period within which to treat the claimant, define what the injury is, define what the treatment is, than they would have at 90 days or the older time frames.
Yeah, let me go to the other judge now in private practice, Judge DeLynn. Why is that such a bad thing? If the panel doctor has more time to really dig into the case, you look at states like New Jersey across the river, the panel doc basically controls the case from beginning to end. Why does that really hurt your case, or why could it hurt your client?
In the 6 or 7 months since I've returned to private practice, I can say that almost 80% of the clients who come to us from the panel come to us as damaged goods. They're distrustful of the system and they're still hurting. The panel doctors that I've seen generally throw pain-killing medication at the injured worker and try to get them back too early. That's the problem. They really are under a tremendous amount of pressure from the insurance companies to get these people back to work. That's the problem.
George,
when they're not ready to go back.
When they're not ready to go back, and George, you think the panel doctors are trying to push them to get back into the...
I mean, and think about it. Come on, let's use some common sense here. If you're a doctor and you get hired by this insurance company to be on their panel, and you start telling the truth and saying, wow, the person can't work, and it costs them money, they're not going to keep you on the panel. They want people on the panel who are going to say what they want them to say. Common sense.
But there is an issue, though, that with private health care providers at an early stage, that oftentimes they're in the system longer than necessary.
Well, it depends. I mean, if you have a person, let's say they have a herniated disc. If a panel doctor doesn't do an MRI, if a panel doctor says, oh, it's just a strain or sprain, get the person back, and as Judge Beach described, they define the injury. What is it? What isn't it? And if it's not a herniated disc, then they go, oh, it's just a strain or sprain. So many times, all the people out there on TV land watching, if they've been on comp, they'll look at their TNCP or their Notice of Compensation Payable that defines the injury. You watch, it's always defined as a very minimal thing. I had a person who had a reconstructed shoulder, 5 surgeries, it had shoulder strain. You know, it was way, way worse than that. And these panel doctors will define things in as minimal terms as they can, because that's their job.
Let's go back to your emails, and again, we're taking your telephone calls at 1-800-426-4625. This from Sandy in Philadelphia. I've been on comp for a year. I sustained severe injuries at work. Now, my lawyer is taking settlement, or is talking settlement with the insurance company, but I am concerned to settle because I'm not really sure what my medical costs are going to be in a few years. This is why we took his email. I would like to settle most of the cases, or I'd like to settle most of the case and keep my medical benefits open, but my lawyer says we won't get a deal unless that is included. Does that sound right? Judge DeLynn, does that sound right? I mean, a person will hear that, right? We're not going to get a deal unless we somehow put medical in the whole package.
It's entirely plausible. Just think, it takes 2 people to make the deal. And if the injured worker's lawyer is saying, we can't settle your case unless you settle the medical part of your case, assuming that lawyer is telling the truth, that case just can't settle if the person needs their medical care. And if they're receiving, it depends if they're filing to get on workers' comp and they haven't had the medical care that they need, or if they're receiving workers' comp benefits and their care is being paid for and they just need some more of it.
Let's go to Bill in Allentown, PA first. Go ahead, Bill, you're on the line.
I was on workman's comp for quite a while, and then my doctor, he quit. And it was about 4 months when I went back to, this happened quite a while ago, and I just wanted to know if I have any legal bindings on this. And when I had to go back, the doctor said that they won't settle anything because they told me that workman's comp terminated me. Now, I made a settlement, and I went up to Scranton, and I wrote them a letter up there, and they said they never have any notification of me signing off or being terminated by the insurance company. So I just wanted to know if I had any legal standings on this.
I think you need to know exactly what the situation is. I mean, the Bureau of Workers' Compensation in Harrisburg has the records of everything. So I would suggest you get a lawyer, and the lawyer will know who to ask. You go to Harrisburg, the Bureau of Workers' Compensation, you get the file from there. Did you sign a final receipt? Was a termination entered against you? What is the official status of your case? That's the first question you need to know the answer to before you can figure anything out.
All right, you'll get a bevy of phone numbers after the show, and if you need to, Bill, you need to get in touch with an attorney or get in touch with us, you'll have that. And as a matter of fact, we're going to stay in the studio for about 10 or 15 minutes afterwards to answer some more of your email questions and your telephone calls, so continue calling at 1-800-426-4625. Let's go to email number 3 from Jan in New Hope tonight. I feel like the company doctor is completely doing my employer's bidding. Can I go to my own doctor and be reimbursed by my workers' comp benefits? So that's close to what we said before, Judge DeLynn, but that last part is a cogent point. Can I be reimbursed, by my workers' comp benefits at a later time if I do go to see my doctor now?
If she's still within the 90 days, there is not a chance that she's going to get reimbursed by going to her own doctor.
Within the 90 days?
Within the 90 days.
But if they didn't jump through those hoops, you see, that's the thing, like what Judge Lynn was saying, if they did jump through those hoops, then they don't. But if they didn't jump through the hoops, and many times I'll find that, did you ever sign an acknowledgement? Did you get the list? Did you pick a doctor? Was it made available? Was it posted? There are things they have to jump through, and I would say most of the time they didn't jump through it. The bigger problem I find is that a doctor won't want to wait for payment, and a person who's out of work doesn't have the money to pay. So to answer the question, it's likely possible that they will be able to get reimbursed. If she can afford to pay her own doctor, definitely go there, because as Judge Beach said, you don't want the other doctor to define the injury. You want your doctor to define the injury. And if it costs you a few bucks, you get reimbursed after you win, and you get a better chance at winning if you have the medical evidence.
What we also find, though, is that she very well may be out of the 90 days, and she's continued to work with the employer. And if she's out of the 90 days, she can select whom she wants to.
Right.
All right, folks, it's hard to believe, but we are running out of time, so we want to remind you, again, we're going to continue taking your phone calls for a bit, 1-800-426-4625, even once we do leave the air. I want to thank my guests for joining us tonight. A quick one, George Beatty with Beatty Sloan and DeGeneva in Center City, Philadelphia. The Honorable Jeffrey DeLynn, now practicing with Krasno and Owen Dinjo in Philadelphia, representing claimants. Barbara Young with Schaff and Young, representing the insurers and the employers. And the Honorable Audrey Beach from the Greater Lehigh Valley Workers' Compensation Judge. And for all of us here at the American Law Journal, until next Monday night, case closed.
This week's American Law Journal has been made possible in part by Beatty, Sloan, and DeGeneva. Decades of experience providing personal attention to those injured at work or suffering from serious injury due to medical malpractice, defective products, motor vehicle accidents, and other causes, with offices in Philadelphia and Haddonfield, New Jersey. And by Krasno, and Owen Dinjo. Since 1936, serving injured Pennsylvanians in workers' compensation and those seeking Social Security disability benefits, with 8 offices throughout the state. And the Legal Intelligencer, the nation's oldest legal newspaper for lawyers.